established under this constitution in the name of the people and in conformity with the laws and values, norms, and aspirations of the people. This principle embraces all judicial power exercised by civilians and military courts. While Parliament established a court martial as an organ, while the court established court martials as organs of UPDF, the authority to vest them with the judicial power must be construed as derived from the constitutional principle. For all courts established under this constitution have a mandate to exercise judicial power. Therefore, although court martial are a specialized system to administer justice in accordance with the military law, they are part of the system of the courts that are or deemed to be established under the constitution to administer justice in the name of the people. In my view, they are parallel but not complementary to the civilian courts. Hence, the convergence at the Court of Appeal level. This observation coming from an eminent judge, Justice of the Supreme Court, puts to rest all those adverse utterances often made in respect to military courts. Some have erroneously gone to the extent of calling them mere disciplinary orderly venues like police disciplinary orderly room. They therefore need to be supported and given qualified legal personnel like they have done in two industrial courts. A specific status which was considered in Attorney General versus Joseph Tumushabe, Supreme Court Constitutional Appeal number 3 of 2005. Justice Mulengo observed in that case, in respect of the court martials, thus, open court. Officer preferring the charge spelled out in the charge sheet, circumstances that bring the accused person under the ambit of the UPDF Act. In the instant case, after giving the description of the accused, stated he was subject to military law by virtue of Section 119 I and G of the UPDF Act. The particular offense must allege that the firearms and ammunition are ordinarily a monopoly of defense forces or other classified stores as prescribed. The particular offense must therefore bring the civilian under the ambit of the military law in terms of Section 119 of the UPDF Act to confer jurisdiction to the military court. Furthermore, the moment the civilian finds himself in the circumstances that make him subject to military law, he can commit a service offense whether under the UPDF Act or any other law by virtue of Section 179, subsection 1 of the UPDF Act. As put by Justice of the Supreme Court in Namugerwa Hadija versus Attorney General Supra, the constitutionality of Section 119 I and G and H of the UPDF Act was upheld by the Constitutional Court in Uganda Law Society versus Attorney General Supra. As observed in Namugerwa case, Supra, when a link is established between the accused and Section 119 I, G, and H of the UPDF Act by stating in the charge sheet that the accused person was found in possession of a firearm, being ordinarily a monopoly of defense forces, then the accused is rightly before the court martial. In the instant case, it was alleged in the particular offense that the firearms and munitions were ordinarily a monopoly of defense forces. This made the appearance subject to military law, and the General Court Martial had jurisdiction to try them through, though they are civilians. Before we take leave of this ground of appeal, we should reproduce the extract from the judgment ordered of Justice Joseph Mulenga, Justice of the Supreme Court, as it then was, for the benefit of the members of the public and any other person who do not fully understand the role and the space occupied by military courts in the administration of justice and how the military courts relate to civilian courts. Some people erroneously equate them and are merely reminded of the Idi Amin's military tribunals, which were, to be more specific, kangaroo courts. And any mention of military court is a sad reminder to those who suffered under such system. In RA/LFK 016 Private Iruwaga Moses versus Uganda Criminal Appeal number 530 of 2014, a service offense under circumstances spelled out under Section 119, subsection 1 of the UPDF Act, he or she becomes subject to military law, and the moment he brings himself or herself under the ambit of that section, he or she falls under the jurisdiction of the military courts. Under Section 119I of the EPDF Act, the following persons are subject to military law. G. Every person not otherwise subject to military law who aids or abates a person subject to military law in the commission of a service offense. And H. Every person found in unlawful possession of 1. Arms, ammunition, or equipment ordinarily the monopoly of the defense forces. 2. Or other classified stores as prescribed. So Section 119 of the EPDF does not create any offense, nor does it prescribe any penalty for any offense. Thus, a person cannot be charged under that section, as that would offend the provision of Article 28, Clause 12 of the Constitution. If a person not otherwise subject to military law commits an offense, service or non-service offense, under circumstances spelled out under Section 119 of the EPDF Act, he or she becomes subject to military law for possession of firearm, and the other being unlawful possession of ammunition. In a case involving unlawful possession of firearm, contrary to Section 3, subsection 1, and subsection 2A of the Firearms Act, it must be proved that A, the accused was in possession of firearm or ammunition, and possession can be actual or constructive. B, the accused did not have firearm certificate. We have also been guided by the principle that in an appeal from a conviction, the onus of proof is upon the appellant, who must satisfy the court that there exists some good and strong ground apparent on the record for interfering with the findings of the lower court. The findings of the lower court are presumed to be correct, and the party who seeks to impeach them must satisfy court that good grounds exist for believing that it is one which, having regard to the evidence and the procedure followed, is unreasonable in the points of fact or erroneous in points of law. Having stated thus, we embark on the resolution of the issues raised in the two grounds above. We think the logical way to proceed is to evaluate the evidence regarding the offences with which the appellants were charged, and as laid in the memorandum of appeal. Furthermore, the appellant denied being a member of the Boda Boda 2010. We, however, think this submission is redundant, as Kitatta was not charged for being a member of the Boda Boda 2010, nor was it alleged that the Boda Boda 2010 was a prohibited organization. Counsel further submitted that first appellant explained his role as a political mobilizer who had been given armed escorts to protect him. That the second appellant, D.C. Ngobi Sowell, who was the first appellant's guard, testified that he had never seen the first appellant with a gun. He submitted on behalf of the second appellant that while he considered he was found with guns, he was officially armed by his deploying commander, senior superintendent of police, Agasirwe Nixon. Counsel submitted further that it would have been prudent to summon the investigating and arresting officer to disprove the second appellant's claim that it was wrong for the trial court to believe the testimony of Agasirwe Nixon on arming the second appellant, but ignored a key explanation of the appellant's evidence regarding the police code 99. When a police officer, even if he did not sign for a gun, but he uses it for an operation, he cannot be said to be in the wrong. It cannot be said to be in the wrong. That the trial court did not properly evaluate the evidence and erroneously convicted that both appellants on weak evidence. The land prosecutor submitted in reply that counsel failed to address himself on the main charge sheet upon which the appellants were convicted and raised other issues which were irrelevant. That there was sufficient evidence that the first appellant was found in possession of a pistol, being a monopoly of defense forces. That the evidence of PW1 was corroborated by that of PW3 on this issue, and the gun and ammunition were tendered in court as exhibit PEX1 and PEX2 respectively. We have carefully considered the submission of both counsel and the evidence, materials on record, and rival contentions, and we have gone through the judgment of the General Court Martial, and we have addressed ourselves to the duties of the first appellate court as spelled out in the case of Chifamontehendo versus Uganda, Supreme Court Criminal Appeal number 10 of 1997, Pandya versus R 1957, East African Law Reports, at page 338, and Bogere Moses and another versus Uganda, Supreme Court Criminal Appeal number 1 of 1997. In essence, these cases have established that the First Appellate Court must review or hear the evidence and consider all the materials which were before the trial court and come to its own conclusion regarding the facts, taking into account it has neither seen or nor heard the witnesses. And